Hello Year 11s and welcome to this video on precedent. As you should recall from our previous video, one of the ways in which courts, that is judges, make law is by making precedents, that is, by making a principle or rule of law when they are deciding a case. A judge will have to make a new precedent where the case they are deciding is not covered by an existing precedent. A judge will have to modify, that is change, an existing precedent where the case they are deciding is similar to a case that is covered by the existing precedent, but it is necessary to expand the existing precedent to cover this new situation. There are 4 things that you need to do as you watch this video. The first thing is to take the very best Cornell notes that you can. The second thing is to use the pause and rewind functions. Use the pause function if you need to stop this video to take notes. Use the rewind function if you want to go over any information contained in this video. The third thing that you need to do is have your vocabulary sheets open in front of you so that you can write into your vocabulary sheets the definitions of key terms and of any other words the meaning of which you're unfamiliar with. And the fourth thing that you need to do is have your summary books open in front of you. I'll give you some guidance as we go through this video as to what you should write in your summary books. Once you've finished watching this video, please make sure that you read the pages from the textbook referred to on this slide. And if you find any additional information from that reading that you think is useful, then include that additional information in your Cornell notes. Let's get started then. On this slide, I've set out the learning intentions for this video. There are 2 learning intentions. Make sure that you write these down in your Cornell notes. The first learning intention is that you need to be able to describe what precedent is. The second learning intention is that you need to be able to describe the 2 types of precedent. Let's start off with our first learning intention, which requires you to describe what precedent is. This slide sets out the definition of a precedent. A precedent is the reason for a court's decision which establishes a principle or rule of law. Look down the left-hand side of your vocabulary sheet, find the term precedent and write this definition in there. You also need to know that the Latin for the reason for a court's decision is the phrase ratio decidendi. Look down the left-hand side of your vocabulary sheet, find the term ratio decidendi and write this definition in there. There are 2 important points about the definition of precedent. The first important point is that a precedent is the reason for a court's decision, the ratio decidendi. The reason for a court's decision is different from the order that the court makes to determine the case before it. So, for example, a court which is hearing a criminal case might decide to sentence the accused to a term of imprisonment. This is an order of the court, but it's not the reason for the court's decision. It tells us nothing of why the court decided that the accused was guilty in the first place. Similarly, in a negligence case, the court might order the defendant to pay damages or compensation to the plaintiff. This is an order of the court. It is not the reason for the court's decision. It tells us nothing about why the court decided that the defendant was liable to the plaintiff in negligence in the first place. The second important point about the definition of precedent is that the reason must establish a principle or rule of law. That is, a precedent is all about legal principles, legal rules, not about questions of fact. So, for instance, it's a question of fact as to whether or not Ben intended to kill Amanda and is therefore guilty of murder. That fact can only be determined by looking at other facts, such as what Ben said and did. In contrast, it is a principle of law that a person can only be guilty of murder if they intend to kill their victim. Likewise, it is a question of fact as to whether or not Havana was acting unreasonably when she injected her sick patient Marcus with an antibiotic that triggered an allergic reaction and is therefore liable in negligence to Marcus for the brain damage that the reaction caused him. That fact can only be determined by considering whether Havana should have known about the possibility of the antibiotic triggering an allergic reaction and about Marcus having an allergy to the antibiotic. In contrast, it is a principle of law that a person can only be liable for negligence if they act unreasonably. As you'll see, when a court is deciding a case, it will look back over previous cases to see whether another court has decided a similar case, and if so, what principle or rule of law, that is what precedent, the court applied. So it is that a precedent, a principle or rule of law that has been decided by one court, can provide guidance to another court about the law that the other court should apply in deciding a later case. There are therefore two advantages of the doctrine, that is the rules, of precedent. The first advantage is that precedents create consistency. That is, precedent ensures that similar cases are decided in a similar way. So, for example, it might be that a court has created a precedent that a toy maker is liable in negligence if they manufacture toys for young children, and it's easy for those children to break off parts of the toy and put it in their mouth so that they choke. What that means is that in all subsequent cases where a young child chokes because they're able to break off a part of a toy and put that in their mouth, then the young child who chokes should be entitled to compensation. That's a matter of treating similar cases similarly. The doctrine of precedent also creates predictability. That is, if a new case is similar to a case that has set a precedent, then the lawyers for the parties are able to advise their clients whether or not the new case is likely to be decided in accordance with the precedent that's already been established. This means that the parties are able to decide whether it is worthwhile taking the new case to court, or whether it is better to avoid the cost and time of fighting the case in court by instead trying to settle the case without going to court. Remember that I've said that a precedent is a principle or rule of law that is established by a judge. This has two consequences. First, precedents are typically created by courts when they hear an appeal. As you know from the video on the Victorian court hierarchy, an appeal is where the parties have had their case determined by a court, but one party is dissatisfied with that court's decision, and so that party requests a higher court to review that decision and decide whether it's correct. One of the main reasons a party might appeal against a court's decision is that the party believes that the court has made a mistake of law. That is, that the court has not correctly applied the law. This means that the court that hears the appeal has to decide what the correct law is. And in deciding what the correct law is, the appeal court might create a new precedent or modify an existing precedent. The second consequence is that jury decisions or verdicts cannot create a precedent. This is because juries only decide matters of fact, not matters of law. Because a precedent is a principle or rule of law, a precedent can only be created by a judge who decides matters of law and not by a jury which decides matters of fact. In addition, a precedent is the reason for a decision, and we know that juries do not give reasons for their decisions, that is, for their verdicts. On the other hand, judges do give reasons for their decisions. They have to write a judgment, and that written judgment will contain their reasons for coming to their particular decision. Now we come to our second learning intention, which requires you to describe the two types of precedent. The two types of precedent are binding precedent and persuasive precedent. You need to be able to define each of these terms and explain why a particular precedent is either binding or persuasive. As you can see from this slide, a binding precedent is the reason for a decision of a higher court that must be followed by a lower court in the same court hierarchy. Look down the left-hand side of your vocabulary sheet, find the term binding precedent and write this definition in there. There are three conditions that have to be satisfied before a precedent made by one court can be binding on another court when that other court is deciding a case. The first condition is that the precedent must be made by a court that is in the same court hierarchy as the court which is deciding the case. The second condition is that the court that makes the precedent must be higher in the court hierarchy than the court which is deciding the case. And the third condition is that the material facts of the case in which the precedent was made and the case which is being decided must be the same. Let's unpack this a bit more. To understand when a precedent is binding, you have to remember the Victorian court hierarchy, which we looked at in a previous video. You'll remember that the High Court is the highest court in the Victorian court hierarchy. The High Court is a federal court in the sense that there is one High Court for the whole of Australia, and it is at the top of each of the state and territory court hierarchies. Below the High Court in the Victorian court hierarchy is the Court of Appeal, and underneath the Court of Appeal is the Trial Division. Both the Court of Appeal and the Trial Division are part of the Supreme Court. Then comes the County Court, and underneath the County Court is the lowest court in the Victorian court hierarchy, which is the Magistrates' Court. Remember that precedent is only binding on lower courts in the same court hierarchy. This is why, for example, High Court precedents are binding precedents for all the other courts in the Victorian court hierarchy. The High Court is the highest court in the Victorian court hierarchy, and all the other courts in that court hierarchy are therefore lower than the High Court. This concept is expressed in the principle of stare decisis, which is the principle that lower courts in the same court hierarchy must follow the reasons for the decisions, that is the ratio decidendi, of higher courts in the court hierarchy. So now you've learned another Latin phrase in addition to ratio decidendi, that is stare decisis. Look down the left-hand side of your vocabulary sheet, find the term stare decisis and write this definition in there. The other important concept that you need to understand is what material facts are. This is because a precedent is only binding in a case where the material facts of the case are the same as the material facts of the case in which the precedent was made. The material facts of a case are facts that are important for the court's decision in that case, in the sense that if those facts did not exist, the court would have reached a different decision in the case. Look down the left-hand side of your vocabulary sheet, find the term material facts and write this definition in there. You'll remember that we've looked at the case of Donoghue and Stevenson, the snail in the bottle case. In that case, Miss Donoghue drank a bottle of ginger beer that was manufactured by Mr. Stevenson. Unfortunately for Miss Donoghue, Mr. Stevenson had been very careless because he stored the empty ginger beer bottles in his garden shed and did not properly wash them before filling them with ginger beer. As a result, a snail was able to crawl into one of the bottles, and it was this bottle, filled with ginger beer, that Miss Donoghue drank. Miss Donoghue only realised that there was a dead snail in the bottle after she had bitten into it and swallowed half of what was now a very decomposed snail. As a result, Miss Donoghue suffered severe gastroenteritis and also psychological damage. The House of Lords, which was the highest court in the United Kingdom, decided that Mr. Stevenson was negligent and had to pay compensation to Miss Donoghue because there was no way that Miss Donoghue could have checked whether the ginger beer was contaminated before she drank it. This is because the ginger beer bottle was opaque. It was made of brown glass, and so Miss Donoghue could not see into it. The fact that the ginger beer bottle was opaque was a material fact in that case, because if the ginger beer bottle had been clear, then the House of Lords would have reached a different decision, namely that Mr. Stevenson was not negligent because Miss Donoghue could have checked whether the ginger beer was contaminated before she drank it. The fact that the ginger beer bottle was opaque was a material fact because, if that fact did not exist, the court would have reached a different decision in the case. All right, we're now in a position to apply our knowledge of what a binding precedent is to an example. Let's suppose that the High Court made a precedent in a case it decided in 2003, and that in 2024 the Court of Appeal is deciding a case with the same material facts as the 2003 High Court case. The 2003 High Court precedent is a binding precedent for the Court of Appeal. That is, the Court of Appeal has to follow that precedent because the three conditions for a binding precedent are satisfied. First, the two courts, that is the High Court and the Court of Appeal, are in the same court hierarchy. They are both in the Victorian court hierarchy. Second, the court that made the precedent, that is the High Court, is higher than the Court of Appeal. And third, the material facts of the 2003 High Court case, that is the case that set the precedent, and the material facts of the case that the Court of Appeal is deciding in 2024 are the same. Remember that I've said there are two types of precedents. One type of precedent is a binding precedent, which is what we've just looked at. The other type of precedent is a persuasive precedent. A persuasive precedent is the reason for a decision of a court that is not binding on another court but is relevant to the case and is an important statement of law. Look down the left-hand side of your vocabulary sheet, find the term persuasive precedent and write this definition in there. The difference between a binding precedent and a persuasive precedent is that where the precedent is binding for a court, then the court that is bound by that precedent, that is, a lower court in the same court hierarchy, must follow that precedent. The word binding means obligatory or compulsory. So a binding precedent is one that must be followed or obeyed. On the other hand, a persuasive precedent is not binding for a court. That is, a court that is faced with a persuasive precedent does not have to follow that precedent. However, even though the court is not bound by a persuasive precedent, it might decide that the precedent is a sensible one, and so it will decide its case consistently with that precedent.
It doesn't have to, but that's a decision it might take.
Put another way, a persuasive precedent is any precedent that is not binding. In other words, a persuasive precedent is a precedent where any of the conditions for a binding precedent are not satisfied. Applying this logic, there are 4 circumstances in which a precedent will be a persuasive precedent. You must know and be able to describe each of these circumstances. In the next slides, we will look at each of these circumstances in more detail. However, in brief, the 4 circumstances where a precedent may be a persuasive precedent are as follows. First, the precedent is a decision of a court in another court hierarchy. This is not a binding precedent because the precedent is not made by a court in the same court hierarchy. Second, the precedent is a decision of a lower court in the same court hierarchy. This is not a binding precedent because the precedent is not made by a higher court in the court hierarchy. Third, the precedent is a previous decision of the same court. This is also not a binding precedent because the precedent is not made by a higher court in the court hierarchy. And fourth, the precedent is obiter dictum of any court. As I'll explain later, obiter dictum is a statement of considered opinion that is not part of the reasons for a court's decision, and it is because obiter dictum is not part of the reasons for a court's decision that it cannot be a binding precedent. Now let's look at these circumstances in greater detail. The first situation where a precedent is a persuasive precedent for a court is where the precedent is made by a court in a different court hierarchy. So, for example, if a precedent is made by a court outside the Victorian court hierarchy, such as where it is made by the Supreme Court of New South Wales, which is part of the New South Wales court hierarchy, or where it is made by the United Kingdom Supreme Court, which is the top court in the United Kingdom court hierarchy, then that precedent can only be a persuasive precedent for any court in the Victorian court hierarchy. It doesn't matter whether that court is the Court of Appeal, as here, whether it's the highest court, that is the High Court, or whether it's the lowest court, that is the Magistrates' Court. A precedent made by a court outside the Victorian court hierarchy cannot be a binding precedent for any court in the Victorian court hierarchy because that precedent was not made by a court in the same court hierarchy, that is, by a court in the Victorian court hierarchy. You'll remember that we have looked at the case of Grant and Australian Knitting Mills, the Itchy Underpants case, which was decided by the High Court. In that case, Dr. Grant bought some underpants that were manufactured by Australian Knitting Mills. Unfortunately for Dr. Grant, Australian Knitting Mills had been very careless in the sense that they did not properly wash the underpants, and so some invisible chemical residue from the manufacturing process was embedded in the underpants. Because the chemical residue was invisible, Dr. Grant only realised that there was chemical residue in the underpants after he had worn them for 3 days and developed a very nasty rash. The High Court knew that the House of Lords had made a precedent in Donoghue and Stevenson that the manufacturer of a product was liable for negligence to a customer where the manufacturer's product was contaminated and the customer could not have detected that contamination before they consumed or used the product. The High Court case of Grant and Australian Knitting Mills was similar to the House of Lords case of Donoghue and Stevenson. In both cases, the manufacturer's product was contaminated by a snail in the ginger beer or by chemical residue in the underpants, and the customer could not have detected that contamination before they consumed or used the product. The ginger beer bottle was opaque and the chemical residue was invisible. Now, the House of Lords precedent was not binding on the High Court because it was made by a court in a different court hierarchy. However, the High Court decided that the House of Lords precedent was a sensible one, and so the High Court decided to follow the House of Lords precedent by also making a precedent that the manufacturer of a product was liable for negligence to a customer where the manufacturer's product was contaminated and the customer could not have detected that contamination before they consumed or used the product. This shows you how a persuasive precedent can influence the decision of another court, even though that other court is not bound by that precedent. The second situation where a precedent is a persuasive precedent for a court is where the precedent is made by a court that is in the same court hierarchy as that court, but where the court that makes the precedent is lower in that court hierarchy. So, for example, if the Court of Appeal makes a precedent, then that precedent can only be a persuasive precedent for the High Court. This is because the Court of Appeal is lower than the High Court in the Victorian court hierarchy. The Court of Appeal precedent is not a binding precedent for the High Court because that precedent was not made by a higher court. Of course, the Court of Appeal precedent would be a binding precedent for the Trial Division, the County Court and the Magistrates' Court because those courts are all lower than the Court of Appeal in the Victorian court hierarchy. The third situation where a precedent is a persuasive precedent for a court is where the precedent is made by the same court in a previous decision. So, for example, if the Court of Appeal made a precedent in 2003, then that precedent can only be a persuasive precedent for the Court of Appeal, that is the same court, when the Court of Appeal is deciding a similar case in 2024. The 2003 Court of Appeal precedent is not a binding precedent for the Court of Appeal in 2024 because that precedent was not made by a higher court. Nevertheless, courts generally follow their previous precedents because this ensures consistency and predictability. It's only in a fairly unusual situation, for example where the previous precedent is very old and outdated, perhaps because of changes in community values, that a court might not follow its previous precedent. The fourth and final situation in which a precedent is a persuasive precedent for a court is where the precedent takes the form of obiter dictum, also known as obiter or obiter dicta. This is the third and last Latin phrase you need to know: ratio decidendi, stare decisis, and now obiter dictum. Obiter dictum is a statement of considered opinion on a matter that is not necessary to the decision in the case. In other words, obiter dictum is not part of the court's reasons for its decision. That is, obiter dictum is not part of the ratio decidendi of a case. Look down the left-hand side of your vocabulary sheet, find the term obiter dictum and write this definition in there. Sometimes when a judge is deciding a case, the judge will state their view of what the law would be if the case was different in some way. For example, if the material facts were different. For instance, if the House of Lords in Donoghue and Stevenson had expressed the view that a manufacturer of ginger beer would be liable for negligence even if the ginger beer bottle had been transparent so that a customer could have seen the snail, then this statement of opinion would be obiter dictum. This is because the ginger beer bottle was not transparent, it was opaque, and so it was not necessary for the decision in Donoghue and Stevenson for the House of Lords to consider what law would apply if the ginger beer bottle had been transparent. Putting this in an Australian context, if the High Court made a statement of obiter dictum in a case, then that statement would only be a persuasive precedent for the Court of Appeal and indeed for any other court. This is the case even though a precedent made by the High Court is ordinarily a binding precedent for all of the other courts in the Victorian court hierarchy because the High Court is the highest court in Australia. The reason obiter dictum can never be a binding precedent is because obiter dictum is not part of the reasons for a court's decision. Of course, if the High Court does make a statement of obiter dictum, then all of the other courts in the Victorian court hierarchy will think very carefully about whether to follow it. They're not bound to follow the High Court's obiter dictum, but because it is an opinion of the High Court, they will give it a lot of weight. Hopefully the information in this video will have given you a deeper understanding of the reason a court hierarchy is necessary for the operation of the doctrine or rules of precedent. We looked at this in the video on the Victorian court hierarchy. Using the counterfactual, we can explain why a court hierarchy is necessary for the doctrine of precedent to operate. If there was no court hierarchy, then there would be no higher courts and no lower courts, and so the rules of precedent could not apply because a court would not know whether they are higher or lower than another court, and therefore whether they are bound or not bound to follow a precedent that has been set by that other court. Now, I want you to include in your summary books a table like that on this slide. Please complete this table by setting out in the table the definition of precedent, the 3 conditions which a precedent must satisfy for it to be binding on a court, and the 4 circumstances in which a precedent will be persuasive for a court. Well, that brings us to the end of this video. As a result of watching and taking notes on this video, you should now be able to do 2 things. The first thing is that you should be able to describe what precedent is. And the second thing is that you should be able to describe the 2 types of precedent. You now need to read the pages from the textbook that are referred to on the first slide of this video. And if you find any additional information from that reading that you think is useful, then make sure that you supplement your Cornell notes with that additional information. Thank you for your attention.